Hi, everyone. Hope y'all are doing well. Just a quick pulse check. Angela, you can hear me, right?
I can. Can you hear me?
Perfect. Yes, ma'am. Just
I
wanted
can
to
hear
double
you.
check. All right, Kathy, thank you for that. We need a pulse check. Seriously, thank you. And just full disclosure to everyone joining us, we're so glad to have y'all here. We've got this set up as a recorded webinar for registrants, and we're also live streaming on LinkedIn. This will be available as a recording that we'll share with everybody additionally, and we'll post on YouTube and pump through the usual social channels. So don't feel too stressed if you miss anything or need to revisit some of this. The materials will all be available. I think we're giving folks just a few minutes to get situated and join us here, but we've got a nice little sizable crowd, and we'll get started here in just 1 second. Again, this is Shauna Elgin. I'm with NSBA. We're so glad you guys are here. A couple of other folks from the NSBA team as well. Ian Elsenbach, some folks might know if you're NSBA members. But we're so excited to do this webinar today with our partner, the American Arbitration Association. Got a couple of folks from their team on the line, but our host from AAA today is Angela Romero. With the German elections, I want to call you Angela just because it's been so much in the news lately. So sorry if that slips out, but you're down in Miami? Is that what you said? Or you're
I
in New
am
York?
in Miami. Yes.
He's making us all jealous today. Oh my gosh. But
Weather is very nice.
okay, you don't need to brag, Angela, but we got a couple of folks still trickling in here, but Angela, if you want to get started in the next just minute or so, or kind of
Yeah.
just start making introductions, I think this is an okay juncture here.
Sure. Thank you so much to you and NSBA for having the AAA and me especially conduct this webinar for small business owners. My name is Angela Romero-Valedón. I am the Vice President of the Miami office of the AAA. I oversee the Southeast, so from North Carolina down south through Florida and Puerto Rico and the U.S. Virgin Islands. And so my role is outreach, business development, and specifically today, education, right? We have a packed agenda. There's going to be a lot of information, but I want this to be as interactive as possible. And so if anybody has any questions, I know, Shauna, you're kind of looking at the chat. And so feel free to have any questions thrown at me. I'll be happy to answer them because I know folks, have a limited amount of time. And so I want to make sure that we get through everything today. And so again, packed agenda, those are a lot of bullet points, but the goal for today is, what is the AAA? What is the American Arbitration Association? What is alternative dispute resolution? Why should you care? Why are you here? Why do you want to learn about different ways to resolving disputes? We're going to talk about what court is, what arbitration is, what are some of the advantages and disadvantages of these procedures. I want to give you an overview of what the arbitration process looks like. And at the end, if you think that you want to incorporate ADR into your business contracts, how do you do that? So let's start with who I am and who I work for. So like I said, my name is Angela Romero and I work for the American Arbitration Association. We are almost 100 years old. That's a lot of years, but we continue to innovate. I think our CEO calls us a 100-year-old startup because we have been at the forefront of ADR and we continue to do so. So again, what is the American Arbitration Association? So we started around 1926 and really was to help out the courts. We are not for profit organization. We act as a third party neutral and we help parties resolve disputes outside of court. That's really what ADR is, a method of dispute resolution outside of the courts. We are headquartered in New York. We have offices all throughout the United States and in Asia. Since 1926, we've administered over 8 million cases. Let that kind of sink in. I will also tell you that in 2024, we administered over 13,000 business-to-business disputes. We have approximately 6,000 arbitrators and 1,100 mediators. And we service different industries. And I think that's important, right? Because not everybody does commercial business. Maybe you're in the construction industry. So we have different industry rules to approach alternative dispute resolution in a very specific way, right? So we have construction, consumer, labor, employment, international. We also manage elections. And we have had opportunity to help those that have been affected by different disasters by managing mediation programs. So what is ADR? So ADR is alternative dispute resolution. And so throughout your life as a business owner and even as a person, you encounter conflict. And so how do you resolve it? So your default has always been, well, I go to court, I sue someone, right? You know, we're in the United States, we sue everybody all the time, but there are actually different options other than court. And we're going to talk today about 3 options. Obviously, built in our name is the word arbitration, but I also want to talk about mediation and negotiation. But I kind of want to leave this graphic here for a second, because again, a lot of you are used to, when you see this, you're like, well, I know what a lawsuit is. But what is arbitration? What is mediation? What is a negotiation? I mean, I think if you have kids, you know what a negotiation is. Even if you have a spouse, you know what negotiation is. So I think at least I know what that is. I have nieces and I'm always negotiating with them. But what is facilitation? What is conciliation? And so, you know, these are some of the things that I want you to think about as we go through, you know, what can I do as a business owner to resolve disputes? So again, what is negotiation? You know, 2 parties or 2 people or multiple people that have differences, sit down and try to resolve them. You know, basically negotiating different terms, negotiating different outcomes to resolve that dispute. What happens when you can't do it by yourselves? You go into mediation, right? And so mediation is similar process, similar negotiations, but with the assistance of a neutral third party. That neutral third party is not going to tell you what to do. It may give you information as to what the outcome would look like if you continue down the path of dispute, or not, right? But that mediation or that mediator really helps the parties to try to get to a mutually agreeable solution. In arbitration, which we're going to talk a little bit more today, is a dispute resolution mechanism it's similar to court. I'm going to talk about court versus arbitration, where a neutral third party, an arbitrator, makes an actual binding determination on that dispute, right? So 2 parties, two businesses that have disputes, say to an arbitrator, a third party neutral, I want you to decide this case. I want you to decide this dispute. Here's the evidence. Here's the information. Please solve this for us. And at the end of that process, you're going to have what is called an award, which is the arbitrator's final order that says who wins, who loses, and what happens afterwards. So I mentioned, why are you here as a small business owner? Why are you here? Why are you learning about alternative dispute resolution? Because there are other alternatives to going to court that can save you time and that can save you money. So think about if you have to go to court for a traffic ticket. Think if you have to go to court for jury duty. You have to take time off your business to do all these things. To go to court, you have to park early. You have to wait until your name is called. Arbitration is the process that's more flexible, that keeps in mind your schedule, that saves you that time, right? It can facilitate the dispute resolution process in your own time, which saves you money, right? Because instead of paying for parking and sitting there and waiting to be called, you can be at home, you can work, and then you can take a break, and then you can address your dispute with the arbitrator and the other party. What if you're a small business that's trying to that you're trying to gather money, you're trying to find investors? Do you really want your disputes to be public? That may, hinder your ability to get funding for some of your projects. Again, you have control over the process. You have a say as to who's going to make that decision in your case. Just think about it for a second. You get to sit down in most cases and look at different candidates that are going to resolve your dispute. And finally, and I think more importantly, whether it is arbitration or mediation, especially I would say mediation, some relationships are worth saving, but the moment that you file a lawsuit against someone, it's usually all bets are off. But with mediation and arbitration, the idea is that you're preserving those business relationships. So I want to talk now what you know about court so that you can compare it in your mind as to what that would look like in arbitration. So you're familiar again with litigation. You may be familiar with court. I mean, there's no Judge Judy for arbitration, but there's Judge Judy for court. So you kind of know what that looks like, right? So for courts, individuals or companies, they file the case. In arbitration, it is similar. However, how you come to arbitration is different. And that is, you need to have a contract. You need to have a contract that calls for this type of dispute resolution. So when you're putting your terms of service, when you are entering into these business relationships, you should have a contract. So I'm going to kind of bring it back to the basics. You should have a contract. And in that contract, there has to be a mechanism on how you're going to resolve those disputes. What I'm offering to you today and teaching you today is these alternatives to that dispute resolution that doesn't involve court. So you looked at your contract and you are in a dispute and it says all disputes arising out of or relating to this contract goes to arbitration using the American Arbitration Association commercial rules. That's how you start an arbitration case, by your contract. So I mentioned to you earlier, who decides your case? And this is important. Again, in court, you have a judge or jury, which if you've ever served on a jury, it's random. If you've ever been in court, the judge, you have no idea who that judge is. You don't know if that judge is on a rotation from family court or criminal court. And then all of a sudden you have this very delicate dispute in front of this judge who may not be familiar with investment, with construction. Now this judge needs to learn an entire industry in order to resolve your dispute. In arbitration, however, you get to see who those decision makers are. You get to decide if you want a construction expert, if you want a franchise expert, if you want a financial services expert. And so who decides your case in arbitration is called an arbitrator. Again, often chosen by the parties, and they are chosen based on subject matter expertise. So that is very basic differences between what is court and what is arbitration. All right. So let's talk about what are some of the advantages and disadvantages of arbitration, because the reality is that no one procedure or process is perfect. So arbitration tends to be faster than court. I will tell you, this really depends on the jurisdiction that you're in. There may be instances where some jurisdictions are faster in terms of court, but I will tell you, the AAA's business to business statistics just came out. And for cases that are $100,000, up to $100,000, the time to award was less than 6 months, so 5.1 months. Now, in district court, the time to award was over 2 years. So just again, think about it that way. How long do you have for your business to kind of stop while a judge decides your case? You don't have that kind of time. So in arbitration, again, it's faster. You get to set the pace, you get to set the schedule in coordination with the other party and in coordination with the arbitrator. And so arbitration can be less expensive. Now, look, the reality is that in arbitration, you are paying the arbitrator. At court, you're not paying the judge. Hopefully you're not. So you're not paying the judge in court, but you are paying the arbitrator in arbitration. So there is that added cost. However, think about business opportunities. What business opportunities are you giving up because you got to go to trial, because you have to be involved in litigation? In arbitration, because it's faster, is going to save you those business opportunities. So at the long run, it ends up being less expensive. Arbitration is private, like I mentioned before. At court, anybody can open the door to that judge's chambers and sit that judge's courtroom and sit and watch your trial go on. In arbitration, that's not the case. It is private, especially if you include in your arbitration clause that the proceedings are going to be confidential, which is important. The entire procedure is confidential, and so again, you don't have the issue of the publicity in the event that you have to file a case against someone. I already mentioned arbitrator selection and expertise, which are 4 and 5. You have a say as to who your arbitrator is going to be, who your decision maker is going to be. You're going to keep in mind what type of industry you're in. So I mentioned earlier, do you want a franchise expert? Do you want a construction expert? Do you want a banking expert? So these are some of the things that you can't go to court and say, well, this judge, I don't know about this person. I think I'm going to change it. You can't do that. In arbitration, through the American Arbitration Association and the commercial rules, you get a list of arbitrators and you have a say as to who the arbitrator is. I already mentioned flexibility. Listen, the cases, and especially the smaller cases, a lot of them go through Zoom or virtual, giving you the opportunity to have that flexibility. We've had cases where parties may work a 9 to 5. And so maybe you need to have a hearing at 7 or 8 o'clock at night. That is possible in arbitration. That's not necessarily so if you're in litigation. And then another advantage of arbitration is that it's final and binding. And you'll see this in the next slide. That is also a disadvantage of arbitration. So I'm going to segue into the disadvantages. And so the advantage of arbitration being final means that it ends with the award. If you know anything about litigation, there is appellate procedures at basically every point in time. So like if you file a motion and you win the motion and the other side wants to challenge it, they can appeal it. In arbitration, it doesn't work like that. You have an award, which is the judge's ruling, the arbitrator's ruling, and that is final and binding, meaning the case ends there. But that isn't a disadvantage of arbitration, because if you lose, you may feel a certain way about the arbitrator's ruling and you may want to appeal it. And so the appeals process for arbitral awards, it's very limited. Under the federal rules, awards are not appealed, they're challenged, and they're challenged based typically on misconduct of the arbitrator or bias of the arbitrator. Now, the AAA does have appellate procedures that you can incorporate in your contract. But again, the idea is that the arbitrator's award is final and binding. Again, it's an advantage, but it's also a disadvantage. Again, if you are not the prevailing party and you want to challenge the award. Another disadvantage of arbitration is that it is less formal. And some, maybe not for you business owners, maybe that you welcome that, right? Because you don't know all the legalese and all the lingo. But for some of you who may have engaged with lawyers, that is a disadvantage for the lawyers. They do want that formality in arbitration. They do want that formality that they're used to in litigation. The third disadvantage is that there's limited discovery. So what is discovery? Discovery is exchange of information. And so in arbitration, to keep costs down, to be effective, the idea is that you're not asking for everything in the kitchen sink from the other side. You're asking for limited information that will help you support your case. And so that is an advantage of arbitration, but also a disadvantage if you think that you are going to be missing out of information because there's a limitation on the information exchange process. I mentioned that there is a cost attached to arbitration. So if arbitration is treated like litigation, which unfortunately some people do, inexperienced parties and inexperienced lawyers may treat arbitration like litigation. It can be costly because, again, every dispute gets brought up to the arbitrator to decide, and you are paying that arbitrator. So the idea behind arbitration is also that it's more collaborative than litigation, because there is an interest between the parties to work together to keep those costs down. A disadvantage of arbitration is enforcement, and I'll pause here for a second. So when a judge issues a ruling, it's automatic. The judge issued the ruling, and people know exactly what to do. In arbitration, the enforcement power is limited to what's in the contract. And so there may be situations during the arbitration where the arbitrator does not have that enforcement power, and the parties inevitably have to go to court. And so you'll have like dual proceedings going on at the same time. It doesn't happen often, but it happens. And I like to, be transparent and give you the information. And then finally, a disadvantage of arbitration is that it doesn't serve as precedent, meaning that an arbitral award, because the procedure is private and it's based on that particular contract, that arbitrator's ruling cannot be used for future cases. So I'll give you an example. If you are a franchisor in a franchisee relationship, you may have multiple disputes during your relationship, right? And you filed an arbitration and you got an award. And let's say that award is completed and the parties do what they're supposed to do based on the award, and a dispute arises yet again. You cannot go back and say, well, this arbitrator issued this award, so we're going to use this for this dispute now. Unfortunately, it doesn't work like that. Whereas, as you know, in court, you have that public case that becomes precedent for future cases. All right. So now I want to talk to you about what does the arbitration process look like, right? So, you entered into a contract, you included in the contract that all disputes will be subject to arbitration utilizing the AAA's commercial rules, the American Arbitration Association commercial rules. You have a dispute, and now you have to file for arbitration. So I want to give you an overview of what that looks like for you. So the first thing is you have to file a case. And the AAA initiates it. So as I said at the beginning, almost 20 something minutes ago, the AAA's role is as a neutral third party that administers dispute resolution mechanisms, including arbitration and mediation. And so when you file a case, that gets assigned to a case administrator. So the AAA has over 800 staff members, from the CEO to our regional liaisons and case assistants. We are all experienced with ADR. And so when you have a case, you get a dedicated case administrator. Which I will say it's a little bit different from court, where the clerks serve the judges. Here in the AAA, the case administrators, we serve the process. We want to make sure that the parties understand what they're supposed to do, what they have to do, that the goals of arbitration are being met. So we are here, the case administrators, which I administer cases. So case administrators are here as a resource. So you have your dispute, you file your case. How do you do that? So we do it online. Again, we continue to innovate, and we have a case filing system and a case management system. And so on our website, adr.org, you're going to click file that case. And what you need in arbitration is a demand for arbitration form, a copy of the contract, and then the filing fee. So I'm going to compare it again to court. In court, you would need a complaint. It's a full complaint, depending on which jurisdiction you're in. You got to set all your facts straight up. In arbitration, we make it simple. There's a demand for arbitration form, and it actually says brief description of the dispute. That is all we need to start your case. A copy of the contract, because we need to know if we have jurisdiction over your dispute. So the contract has to have that arbitration provision or ADR clause that calls for the AAA. And then the filing fee, which is based on the amount. It's a range between, depending on the amount of the claim. That's day one. On day 14, the respondent, so the claimant is the person that's filing the claim, the respondent is the person responding to that claim, the claimant has 14 days from the initiation of the case to answer the case. I'm going to give you another difference between arbitration and litigation. If you're the respondent and you don't want to answer, guess what? You don't have to. It's not mandatory. But in court, you have to answer. If not, you're defaulted against, meaning you automatically lose. That is not the same in arbitration. In arbitration, the respondents do not have to file an answer. It just means that all claims against the respondent are deemed denied. The next phase in arbitration, so you filed your arbitration, it gets routed to a case administrator. That case administrator initiates the case, sets a deadline for the response, and the next big step in arbitration is selecting that arbitrator. So we talked already about you get to decide who is going to be your decision maker. You get to look at our different arbitrators depending on the type of case that you have. You get a list of arbitrators, again, depending on what your arbitration clause says, but typically you get a list of arbitrators, and we want both sides, both parties, to agree to this arbitrator. If you cannot agree, there's a mechanism in place for that we call rank and strike. You want to rank those arbitrators in order of preference. You want to strike those arbitrators that you just definitely don't want us to consider, and we appoint the highest ranked arbitrator to serve in your case. Now, keep in mind, cases usually go through, are decided by a single arbitrator instead of a 3-member panel. We encourage, and our rules require that cases that are 3 million and above proceed with a 3-arbitrator panel. We actually encourage parties to try still to keep it to a single arbitrator, especially if it's a simple dispute. Just because it's a $3 million case, it doesn't mean that dispute is complex. And so I will tell you, our research shows that 3 arbitrators cost 5 times as much as a single arbitrator. We call that arbitration math, and I'll tell you why. Because people forget that arbitrators have to talk to each other when they're making decisions. And so the time that the arbitrators are spent talking to each other, that gets billed to the parties. That gets billed out to you. So if you are drafting your contract and you're going to include arbitration, and you say, you know what, I want 3 arbitrators for all my cases, just keep that in the back of your head, that it's going to cost you a lot more money than a single arbitrator. I want to pause here and talk just briefly about the AAA commercial rules. The AAA commercial rules were updated in 2022. The prior version was from 2013. But what I want to point out about the rules is that we have subset rules depending on the claim amount. So let me explain. If you have a dispute where your claim, the damages that you're claiming, is less than $100,000, you are going to be under the expedited track. That is the fastest track that AAA has. Typically, those cases are addressed within 5 months. As I mentioned to you earlier, 5.1 months is the median time from filing to award for those cases that are up to $100,000. In those cases, in the expedited track, arbitrators get paid a flat fee that the AAA sets. And so for smaller cases, $25,000 or less, those are documents only cases. So I'll explain. You have a right to a hearing, just like you have your day in court. You have your day in court too in arbitration. So you have a right to a hearing, and you can request one. For cases that are up to $100,000, it's usually 1 hearing day. Now, for cases that are smaller cases, $25,000 or less, to, again, save time and save cost, those cases don't have a hearing, and the arbitrator decides it based on the submission that the parties are going to give that arbitrator. There's another track, we call them tracks. So that was the expedited track, and there's a documents only track. We have a regular track, which is $100,000 to $1 million. Those cases, again, are decided by a single arbitrator. And then we have a large complex commercial track, and those cases are from $1 million and above. So there's a couple of nuances that I don't want to just get into because of time constraints. I want to make sure that I give you time to answer questions, but I did want to give you the understanding that the rules are really tailored for your dispute. And so when you're thinking about what is that going to look like? What if I have to go to arbitration? Understand that we have rules that will apply to your case. So you selected the arbitrator. I'm going to go back. We selected the arbitrator. What's next, you ask? It's a preliminary hearing. So that is the first call. Usually we have it be a Zoom, but it can be by phone. That is the first call you as the parties and your lawyers, you're going to have with the arbitrator. That is the call that sets the tone for the rest of the case. During that call, you are going to set your case schedule, which includes a hearing if you're going to have one. You're going to talk to the arbitrator about expectations. You're going to talk to the arbitrator about what is information exchange going to look like? When am I going to get that hearing? How is that award going to be written? When is it going to be due? What do I need to do to get my case prepared for you, Miss or Mr. Arbitrator? That is what you're talking about during that preliminary hearing. Okay, there we go. Once you have the preliminary hearing, at the end of the preliminary hearing, you're going to have what is called a scheduling order. That is a roadmap. That's going to be your map for the rest of the case. It's going to give you all the deadlines that you need to meet in order to have your case ready for that arbitrator. Including in that order is going to be an itemized information exchange, is going to say what you can ask of the other side and what the other side can ask of you, right? So if you have a breach of contract dispute, there may be some emails that you need to take a look at regarding how that dispute started and how it ended. There may be some other documents. There may be some witnesses that you want to list and that you want to interview and that you want to talk to. And so there's mechanisms built in the scheduling order for you to do that. And this is the information exchange of the case, right? So once you have that scheduling order, everybody kind of goes to their separate corners and starts preparing that case for the hearing if there's going to be one, or you start preparing your submissions, which is that group of documents that you're going to put to the arbiter can decide your case. So again, about 30 minutes ago, I mentioned the word mediation, and you're like, well, Angela, you haven't talked about mediation at all. Okay, so I'm going to talk about it now. Mediation is, I will say, and not because I'm a former circuit certified mediator in Florida, has nothing to do with that, but mediation is a great tool that every business owner should know about and should have in their back pockets. If you did not include mediation in your arbitration clause, think about it. You should include it. I'm going to tell you why. Because if you have a business relationship that you know has to go on, the best way to resolve the dispute is through mediation. When you have two willing parties that understand the cost of any sort of dispute resolution, arbitration, or litigation, you need to have mediation as an alternative. Again, I remind you, mediation is the opportunity that two parties have to sit down with a neutral, and that neutral, who is the mediator, is going to help the parties resolve that dispute, maybe by putting ideas, maybe by going back and forth and giving you different opinions or different options that you can look at that you hadn't thought about. But that arbitrator is a facilitator. That person is the go-between two disputing parties that will help them resolve the disputes. And so the AAA, again, because we want to make dispute resolution accessible and affordable, we have a fixed rate mediation program for cases that are $100,000 or less. So under the commercial rules, any cases that are $100,000 or more, the parties have to mediate. But it's optional if your dispute is $100,000 or less. But again, because we want to make you think about the cost, you have to do a cost benefit analysis of what is going to look like if you resolved the case through arbitration from start to finish. What is that cost going to look like? Well, if you mediate, what is that going to look like for you? You're going to save time, you're going to save resources, and you're going to save business relationships. And so this is why mediation is important. I will tell you, under our rules, you can mediate at any point in time, whether it's at the beginning of the case, in the middle of the case, even after the hearing, if you want to, as long as obviously you do it before the arbitrator issues their award. But I will tell you that in cases where you have a case administrator, you will have information about AAA mediation. We have, as I mentioned earlier, over 1,100 mediators throughout the United States. And mediators that are not only lawyers, but that are also executives, that are industry experts that can help you resolve those mediations. Okay. Getting down from my mediation soapbox, getting back on my arbitration one. All right, so you have your scheduling order, you went through all of the deadlines, you met them, you submitted everything to the arbitrator, and now you're prepared to present your case. If you're in the expedited track, there may be 1 day of hearing. If you're in documents only, that just may be the submissions, the documents that you're going to submit to the arbitrator. If it's a larger cases, you may have more than one hearing day. You may have 2, 3. If it's a very complex case, it can be weeks of hearings. But understand that is going to cost you more money the more hearing days you have. However, the final hearing, it is your quote unquote day in court, right? It's the time where you put forth your case to the arbitrator and you make a case for them finding on your behalf. I will tell you that most hearings nowadays are hybrid, meaning that parties are in person. Maybe maybe an arbitrator is in person as well, but maybe some of the witnesses are not. You can also request a hearing to be held by video. The arbitrators under the commercial rules are empowered to determine the mode of the hearing. And so for taking into account expediency, flexibility, and cost effectiveness, they may order the hearing to go virtual. Okay, so sometimes even after the hearing, parties still have a lot to say. And so we have a post-hearing submission procedures. These procedures are usually reserved for, again, larger complex cases. If your dispute is a smaller dispute, you had either your documents that you submitted to the arbitrator or you had the final hearing. But in larger complex cases, we do want to give those lawyers more opportunity to present their evidence or to kind of close off any points that may have been left off during the evidence presentation. And then finally, you get the decision from the arbitrator. For cases under the expedited track, think about it. The award is due 14 days after the hearings close. How long sometimes do you wait for a judge's ruling? It can take weeks, it can take months, depending on the complexity of your case, right? So in the larger complex cases, in the regular track cases, it is 30 days from the close of the hearing. And so within 30 days, you're going to get a decision one way or on another, and you can go about your business once a decision is made. And then the case is over. If you did incorporate appellate procedures, the AAA appellate procedures in your contract, then you would have an appellate procedure. Those appellate procedures, I usually don't go into it in depth just because for time's sake, but I will give you this. The appellate process in the AAA is meant to last 120 days. give or take. It is decided by 3 arbitrators, and the decision power that the arbitrators have is very, very limited. The rules also have their own briefing schedule already built into it, so there is some predictability as to how long and what you need to do to get that process in place. There's usually a timeline after the award within which the parties have to file the request for the optional appellate procedures. Now, you only get to the AAA's appellate procedures if you include it in your contract. Okay. So we just have a couple more slides left. I know your heads are probably throbbing at this point with all this information, but we talked about cost, we talked about efficiency, we talked about flexibility, we talked about decision makers, we talked about dedicated case administrators. We at the AAA, we're neutral. We don't have a stake in the action. We just want to make sure that the parties comply with the rules, that the arbitrators comply with the rules, and then at the end of the day, you have a valid binding award. Part of our role, as I said, is education and resources. We are your resources. If you have questions about our rules, send us an email. We will answer them for you. So you're like, you know what? This lady has a good point. What do I do now? So this is what you do now. You look at our clause builder tool. So again, as a not-for-profit organization, if you go to our website, adr.org, there's tons of resources for you there, including free tools. Our clause builder tool, it's a Q&A on-demand tool where it will ask you questions so that at the end of that Q&A session, you have a valid enforceable ADR clause. It's going to ask you, how many arbitrators do you want? How do you want to select those arbitrators? Do you want to include mediation? The answer should always be yes. Do you want to include where that arbitration or mediation is going to take place? The answer is yes. Do you want to talk about state law? Do you want to talk about discovery? Maybe you just want the procedures to be by documents only. So there's different provisions on that website that you can select to incorporate in your ADR clause. And then hot off the presses, Clause Builder AI. The address is there, clausebuilder.ai. It is built on ChatGPT's platform, but it learns from itself and not from outside third parties. So whatever you put in is confidential because that's all that, that's a key component, right, of this entire procedure is privacy and confidentiality. And so you can prompt it like you would prompt ChatGPT and say, hey, please build me a clause that incorporates mediation for my franchise transaction. And let's say that you want a single arbitrator and you want the locale to be Washington, D.C. Once you prompted that clausebuilder.ai will give you a valid arbitration clause, and it will make other suggestions like how about including attorney's fees? How about including discovery? Do you also want to include what type of award do you want? So these are some of the items that I just mentioned that a clause should have and that you should be thinking about when you're putting together your ADR clause. Right. And then finally, for all of you small business and entrepreneurs, we have a dedicated page just for you that serves as it gives you a lot of information, education and tools. They're all free. Please, go. There's a guide to arbitration and mediation that is free for you to download. We also have webinars. Go to aaaeducation.org. Empower yourselves. We have a ton of webinars on arbitration, on mediation, the power of mediation, the power of arbitration. Like I said, we have some free guides for you. And so, at the end of the day, the goal, I'm sure, from NSBA and from us is to empower you to help yourselves when you have a dispute unfortunately, in this world, disputes are inevitable, and just how you handle them is the key. And so this has just been my opportunity to educate you and give you just another alternatives, right, to resolving disputes. And so Shauna, I think I'm good with time, so I want to open it up to any questions that anybody has.
You were perfect on time, Angela. Thank you so much. That was such a thorough but concisely presented notion of what arbitration is and what it does. Just personally speaking, my favorite part about our partnership with NSBA and the AAA, I asked you, what are your objectives? When we got started, I remember asking, what are your objectives? And it wasn't to earn memberships or find new partners. It was sincerely to inform small businesses so that they might be able to include these clauses and expedite how, like you said, disputes are handled within their enterprises. It's just really fantastic. I think it's so tremendous that you guys have all these tools available. And I was really just stalling to make sure all of the questions had maybe been answered by your colleague over here on the side. I know you gave a lot of insight over here during the program, which is fantastic. And I think you covered a lot of it. But Charles, you had a ton of questions. Did we cover everything that you were kind of outlining for us? I think very helpfully, I might add. I see one question here. Samantha, you asked if we would have the slides, and just quickly, maybe before Charles hops in, we will be sharing this with registrants. We're very happy to provide this information. I think if you don't overwhelm Angela, her contact information is in there as well, and I think she'd be very happy to answer any more questions. I know some of this gets specific, right? Like Charles had a question about, when can a party? Hi, Charles. You're ready to talk now. I'm sorry, sir.
I
Okay, go
am.
ahead.
I am.
Go
I just
ahead.
can't turn on my camera, but I could talk.
No, that's okay. That's okay. Thanks for joining us. Go ahead.
Thank you. So, Angela, thank you. First of all, thank you for covering all that ground. That was really informative and helpful.
My pleasure.
So both parties have to bind themselves or agree to be bound by the arbitration process. At what point can that consent be revoked? So let's say that they feel like the proceedings aren't going that way. They say, you know what, I want to withdraw my consent to be bound by arbitration. Is that a thing?
So we do at times get the filing party, which is the claimant, withdraw their claims. However, I think the situation you may find yourself in is that if you then want to go to court, the court may look at your clause, at your contract, and say, why are you here? You're supposed to go to arbitration because that's what you contracted for. It may send you right back. But you came to arbitration because, like you said, two willing parties negotiated and added, ADR into their contract. And so, if the other side also agrees and says, no, we rather go to court, you can stipulate to that and, write something up that says, we're not going to go to arbitration. We're going to go to court, and you present it to a judge. And again, as long as both parties agree, I don't see why the judge would turn the case away. But understand, if it's unilateral, that's when you may run into an issue.
Got it. Okay, and then the second question that it looks like O'Rourke was trying to get to answer for me. Here, let me paint it. Let me paint it a little basic. There are certain tiers where you get an express hearing, and then higher tiers where it's more complex. Is it
Correct.
possible to, let's say, have a $30,000 case decided at the complexity of a $200,000 case?
Well, the answer is yes, but it depends. Again, this is a party-driven process, right? So what that means is that the two sides are usually in the driver's seat, and you have the arbitrator as a passenger, but a very, very close passenger. So think of it as when you were learning to drive and you had the instructor that also had a wheel and had a brake. That is your arbitrator. So the rules empower the arbitrator to make a ton of decisions, again, keeping in mind the goals of arbitration. So if you want to litigate a $30,000 case like you would a $200,000 case, you're going to have to justify it to yourself, to your shareholders and stakeholders, and your lawyer has to justify it to you if you're being represented by a lawyer, because it's not meant to be that way. We set up the rules in a very specific manner. So again, we're keeping in mind efficiency and cost effectiveness. So to answer your question is a yes, but is an it depends. If arbitrators are empowered to basically stop the parties and, you know, help the parties from themselves, by utilizing procedures that are outlined in the rule for those specific cases. But listen, you may have a $30,000 case that is complicated, and can be addressed in a more complicated manner, or it can be addressed in more using more of the complex rules. But when you have to think about time and cost, again, you're going to have a heart-to-heart talk, you know, with the powers that be on your end.
Got it. Okay. All right. Thank you so much.
Thank you, Charles, for those questions.
Sincerely, they
There's
were
more.
very,
I'm just being courteous here.
they were very helpful. And another question we had was if we could get a copy of them with the slides. And absolutely, I'd be happy to extract the questions asked and then the few short responses kind of preliminarily here that I think are a good jumping off point for you to visit the AAA website and explore their resources further. You know, like we said, answering these questions specifically, hard to do in a webinar, but I think a really good starting basis here to get people keyed into the benefits. And I like that you also talked about kind of some of the disadvantages of the AAA, but as you were naming every single, not the AAA, sorry, of ADR.
Okay. Yeah.
But as you were naming them, you know, I'm just thinking even comparable to court, some of these aren't disadvantages. You know, you talk about docket delays, you know, expenses there. There might be expenses here, but it can be triple in a legal system. It's very insightful information.
Yeah,
I
I
know
think, yeah, business owners just really, you know, ADR, and when you're putting together a transaction, you know, the ADR clause, the dispute resolution clause is always the last one that goes into the contract. And so hopefully after this webinar, a lot of you will not make it your last. I will also make it as a priority, and look at, you know, how is this going to fare out if I have to go to arbitration or if I have to do mediation, versus going to court. It's just a balancing of factors. You have to, again, have those tough conversations with all the parties that are involved and say, you know, well, you know, we should try this and we should see how this is going to look like for us, you know, 3, 4, 5 years down the road. Because right now the relationship is great and you're entering into it and you're not thinking that it's going to go sour. But, you know, 3, 4, 5 years down the line, stuff happens. So what are you going to do then when 5 years before you didn't sit down and went through, you know, all the parameters and all the options and the advantages of disadvantages when you were putting together the deal?
what makes small business so great and I think so tricky sometimes is that you do work with people that you're close with, just inevitably. There are families that
Yes.
are involved and nobody
Mhm.
likes to anticipate the worst, but that's exactly why the whole legal convention, you know, even exists in the first place. And I think even why arbitration became an extension of that, productively so, I would unsolicitedly say. But
No, that's true. You know, I make a comment usually to these presentations that everybody knows a business owner, right? 99.9% of all businesses are small business owners in the United States. In my family, I can tell you there's about a handful, and none of them have a contract, and it drives me crazy. And I'm like, hello, do you not know what I do for a living? And so I wish that they would sit for these webinars and listen to you know, me talk and listen to all these advantages and all these different tools that we have. And so I think it's wonderful that you put this together. Again, I believe in education and just empowering the small business owner to take you know, take destiny with their own hands and say, okay, we're putting this deal together. We're going to talk about what happens if it goes wrong.
Charles had one more question about if you could be represented by a non-attorney, and I think that could be our last one to kind of close us out
Yeah.
here.
Um,
Keeping an eye on time.
So I will tell you that because arbitration is private, usually those businesses and business owners and their representatives are allowed in arbitration. However, we have a ton of resources for pro se parties, which is those parties representing themselves. And I believe those are linked in our small business and entrepreneur dedicated webpage.
This has been extremely helpful. Thank you so much to your entire team. I know NSBA is super proud of our partnership and anything that we can do to empower our small business members to be more prepared, to be better small business owners. We definitely want to do. You guys are helping us do that. Charles, I love that you ask all of these questions. We're going to get you connected with the team so that you can follow up. Thank you so much for making this a dynamic discussion, to everybody here participating, to all of our folks on live who might be joining us as well. If there were any technical difficulties, I apologize in advance. We'll be running this as a recording, sharing all of this information. And as always, you can visit the NSBA website for access to the AAA's information, or their great website as well.
Thank you,
Angela,
Shauna.
thank you guys so much. We really appreciate y'all.
Have a great day.
We'll speak soon. Thanks, everybody. Have a good one.
You too.